effectively remain threatened at the present time. Finally, the co-lawyers denied the risk to Kieu Samphan's safety if released. They submit that the risk referred to by co-investigating judges is neither real nor current. It is simply presumed and purely hypothetical. Therefore, the co-lawyers conclude that the release of Kieu Samphan is currently the only appropriate measure, as his detention is arbitrary owing to fundamentally flawed proceedings and unjustified due to the lack of diligence in the conduct of proceedings. In addition, the co-lawyers argue that detention aggravates the charged person's state of health and that could ultimately be found to be an offense against his dignity. The co-prosecutors respond that the co-lawyers have not identified any material evidence or change of circumstances to justify the provisional release of the charged person or even a change in the conditions of detention. With regard to exerting pressure on witnesses and victims, the co-prosecutors point to past threats of retaliation on the part of the charged person as demonstrating a concrete risk of interference arising from both the charged person's past actions and his present influence. The co-prosecutors also argue that the co-lawyers have misrepresented the current state of affairs in Cambodia and that the release of a person alleged to be amongst the senior leaders of the Democratic Cambodia regime would be likely to cause negative reactions among the population. Finally, the co-prosecutors submit that recent statements and behavior of some victims of civil parties show that any release of the 5 charged persons may degenerate into violence directed against the former Khmer Rouge leaders, including Kieu Samphan. In addition, the co-prosecutors submit that arguments made by the co-lawyers contending lack of diligence are unsubstantiated and irrelevant, and that no bail order would be rigorous enough to satisfy the needs to protect the charged person's personal safety, to preserve public order, and to prevent a charged person from exerting pressure on witnesses and victims. Phnom Penh, 25th of February 2009. Co-rapporteurs Judge Hudbuthi and Judge Rowan Downing. The President, Mr. Kieu Samphan, would you like to make a statement related to your appeal, or if you would like your co-lawyers to speak on your behalf? Kieu Samphan, I would like to give the right to my lawyer to speak on my behalf. President, please sit down. The civil party lawyers, I note your was about to make any comment.
Yeah. Good morning, Mr. President. Good morning, Your Honors. Good morning to everybody. I would like to make at this stage of the hearing some preliminary...
Je souhaite à ce stade exprimer.
And if you allow to do so, on behalf of the civil parties, I would like to make these remarks to present brief oral observations in this appeal hearing. The co-lawyers of the civil parties did not file a written submission to the appeals of the defense within the deadline, nor did they submit a written pleading. Due to limited resources, the co-lawyers are not in the position to address all appeals of the defendants. However, the pretrial chamber ruled in their recent decision on the relationship between the internal rules and the Cambodian Criminal Procedure Code that, I quote, civil parties are thus allowed to raise the issue of the applicability of the internal rules whenever they deem it necessary to do so. This is the case. Today, the matter of provisional detention will be discussed, and civil parties' rights, like the right to reparations and is this okay with the technique, or are there any problems?
No, there is no problem with the technique. I was just wondering how I should see the oral submissions in relation to this appeal.
How you see the oral submission? I would like to, as you stated in the decision by 25th of February, civil parties may raise the applicability of internal rules whenever they deem it, as I said, necessary to do so.
But of course within the existing regulations.
But I add new arguments, and therefore I would like to make this short statement, and referring also, we have a new case, and you ruled that you will decide every case and upon its merits, and the situation is different here because civil parties' rights are directly concerned, and this is a difference maybe to the situation in December. Could I?
Yes, but within the existing regulations, the pretrial chamber directed that if any new circumstances occur which makes it necessary for the civil parties to review their position, in this sense that prior to the hearing that you have developed the view that you want to raise oral submissions, that you could announce that to the other parties.
But however, there are new arguments, and therefore I would like to make this, it's really a brief remark, and would like to continue, because first we have civil parties' rights concerned, and secondly the reasons why are different, or in part different.
Would you allow the bench to talk this over?
Mrs. Stadinsky, could you inform the court or the chamber what notice you have given to the prosecution and the co-lawyers of your application at the moment?
We did not give any notice to the parties about this application, or let's say preliminary remark in this hearing. But however, maybe you could ask the parties and give them the right to be heard and to take any, give their opinion if they object these preliminary remarks.
Your Honor, could you please turn off your mic? Well,
Mr. Dinsky, we have in the past made it clear that there is to be an orderly procedure here and that people are not to be taken by surprise. You come to the court today without having given notice to the other parties concerning that which you wish to say. What you appear to be raising may be fundamental and should have been the subject of notice, so that the other parties could have been prepared to deal with these issues that you now raise. We are not prepared to hear you on the matter in these circumstances.
Am I right that this is a decision that the pretrial chamber has taken on this request to make preliminary remarks?
Yes, that is correct. We do not wish to hear from the other parties. We have made it clear in the past what the views of this chamber are concerning applications without notice. Other parties have to, as a matter of fairness, know what is going to be presented and what they have to answer in this court.
But I suggested to ask the parties if they object and if they agree. It is nothing really new and very new that nobody can or has any idea what I'm saying. I'm not talking about something very, very strange, what have never been discussed or raised.
The parties have not come prepared, and we are not prepared to proceed on the basis of surprise. We have already indicated that notice must be given. You have not given that notice. There were weeks, months, in which notice could have been given, and you come to court today and mention this matter by way of surprise for all. So that is the ruling of this court, and we will not be proceeding to hear you on the matter.
the President, I would like now invite the Defense Counsel to make your oral submission. You have 1 hour for both of you. Now you take the floor.
The Defense Council, Mr. President, Your Honors, good morning, Mr. Co-Prosecutors, good morning to civil parties lawyers, and my respects to the victims and the public in the public gallery. Before I respond to the allegations as in the report of the co-rapporteurs, in today's hearing, I would like the pre-trial chamber to combine both appeals, that is, an appeal on the release for the provisional detention and another appeal on the extension of provisional detention of Mr. Kieu Samphan for another year. If the PTC permits, I would like to respond to both appeals and to take the observations from the co-prosecutors. The President, the co-prosecutors, do you have any comments to make regarding the request by the Defense Counsel? The prosecutor. Thank you, Your Honor. In today's scheduling of the hearing, there are two parts. One is regarding an appeal against the release on bail, and another appeal on the extension of provisional detention of the charged person. Therefore, the prosecution has prepared according to the scheduling, and it should not be changed. It means we have to deal an appeal by an appeal in that order. Thank you. The President, the pretrial chamber considers that in the proceeding, and you know that the proceeding today is divided into two parts, and you did not object to the proceedings. Therefore, the pretrial chamber will maintain the same proceeding, which is divided into two parts. However, in the afternoon, you can rest what you have said in the morning again, if you wish. Thank you. The Defense Counsel. I do not want to cause any difficulty, but actually want to save time. That's why I request it. And it is also based on the pretrial chamber's decision, as I have it in my hands in the French language. It's the last part before the decision.
L'appel contre l'ordonnance de refus de mise en liberté pourra se tenir prochainement et que cet appel
for release, and that this question raises matters that are closely linked to the order. Quote. That is the appeal against the order extending detention. The chamber will hear the two appeals jointly.
However, I would accept the decision of the pretrial chamber, and if I have the right to respond to the co-rapporteurs, I would do so. With your Honor's permission, I would like my clients to sit next to me. Because the other parties want to make their comments heard as well. The President, the charged person may sit next to the lawyers. The co-defense lawyer. Thank you, Your Honor. Thank you, the President, for allowing my client to sit next to me. I would like to respond to the report that the National Co-Prosecutor just answered. I would like to request the release of my client for the following grounds. In principle, the detention is the loss of his right, freedom. And according to the judicial practice, it is only necessary to detain a person. However, there are also other measures not to detain in order to preserve the evidence, to protect the safety. But my client has been in detention for 1 year now, and I would like this matter to be considered. Because this detention is based on the reasons that if Mr. Kieu Samphan is released on bail, he can exert pressures on the victims or witnesses not to appear before the chamber. And if he was to released on bail, Mr. Kieu Samphan may threaten In addition, if he were to be released, there could be public disorder in the current situation. These are the reasons raised by the co-investigating judges based on their introductory submission. I would like to respond to these reasons for his detention. Up to today, he has lived for 10 years in Thailand, and until this hour, I have not seen the co-investigating judges prove any evidence that Mr. Kieu Samphan write any letter to anybody to threaten somebody else. And if he were to release on bail, he could intimidate other witnesses so they dare not to speak. And not only that, but the co-investigating judges also observed that although 30 years after those crimes, the anger